The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have 6 cases that will be submitted this afternoon. Those cases are as follows. State of Iowa versus Sivan Props. Second case is State of Iowa versus Patrick Letcher. The third case is Shannon Breeden and Laura Hockmuth versus Iowa Department of Corrections. Fourth case is Sean James versus State of Iowa. Fifth case is State of Iowa versus Eric Coleman. And the final case is State of Iowa versus Iowa District Court for Jones County. The last 3 cases are now submitted to the court without oral argument, and we'll hear now the arguments in State versus Props. Mr. Racette.
Your Honor. If it please the court, Counselor, this is a case of a young man at 17 years old who committed an act of shooting another individual 4 times. Luckily, that individual did not die. As a result, he was initially charged with second-degree murder, which is has a mandatory minimum of 70% of the 50 years, which is a 35-year charge. He ended up pleading and being sentenced on the same day to 4 counts of willful injury causing serious injury. Each one, he was sentenced on each one for a Class C felony, 10 years as a forcible felony consecutively. That ends up being 18 years. That is an 18-year prison sentence under the IDOC guidelines. I think the court's probably, I'm sure, well acquainted with this line of cases that are coming down from the federal cases that with the trilogy of Simmons, Graham, and Miller under the 8th Amendment, of course, holding that it is cruel and unusual punishment under the 8th Amendment to sentence a juvenile for murder to a mandatory sentence without a chance and opportunity for parole. This court then addressed it initially in Raglan and addressed Governor Branstad's executive order of 60 years without giving credit for time served before any juvenile would be available for parole. The court, as I understand it, applied at that time the federal trilogy and 8th Amendment concepts and said that was equivalent to a life sentence and applied the principles of Miller to make a personalized, individualized sentencing of that juvenile under those circumstances, despite Governor Branstad's executive order. The next cases that came...
Just for clarification, the 40-year sentences, we had the 10, and then they were stacked for a total of 40 years. Were there any mandatory minimums attached to any of these sentences?
Of my client, Your Honor, sorry, I didn't hear it. For this case? Yes, there were not. Okay? We are challenging this solely on the forcible felony sentencing scheme, and we're alleging categorically it's unconstitutional, and then as it applies to my client. The court then went and expanded on these federal trilogy under Article 1, Section 17 of our Constitution, the Iowa Constitution.
Let me move it along. I mean, in Lyle, we said that mandatory minimums generally were subject to our version, if you will, of the Miller-Roper-Graham trilogy. So if there was a mandatory minimum of 5 years or 3 years or 7 years or 8 years, that would allow the defendant to make an individualized showing. Here, in one sense, there's no mandatory minimum, as you just stated.
We do not dispute that.
On the other hand, it seems as a practical matter, because probation is not available, there will be some incarceration. So it's kind of a mandatory, uncertain length of time, if you will. And so the question is, why does that mandatory but uncertain length violate the principles of our cases. I mean, we scrolled it down in Lyle to mandatory minimum sentences. This is a mandatory sentence, but in a way not a minimum other than maybe a practical minimum. I mean, there's going to be a day in jail, I suppose, necessarily. But it's uncertain. The length is uncertain. And why does that give rise to the constitutional challenge you're presenting?
Well, the reason I'm here is because I read Null, and I read Null carefully, and I quoted it extensively in my brief, and I quote to you, we conclude that Miller's principles are fully applicable to a lengthy term of years of sentence. And the court goes on and says, these concepts are constitutionally based on the constitutional concept that juveniles are constitutionally different from adults as to culpability in crimes. And the factors they point out are, number one, their characters aren't fully developed. Number two, their judgments aren't fully developed. And number three, they're more susceptible to peer pressure. And that makes them constitutionally less culpable. The court said, we don't look to mandatory, not mandatory, forcible felony. I believe the court's rationale applies to juveniles, and then the court has left open the question, in my mind, under your rulings, as to the length of the term that you're going to will trigger the Miller concepts of having a personalized sentencing. Because, for instance, the state in this case says, well, geez, it's all mandatory minimum. You don't have to worry. Indeterminate sentencing, the parole board will take care of that. Well, I don't know. I don't believe that you can delegate a constitutional requirement for the judicial branch of government to an agency. And first of all, we don't even know.
But in effect, that's what we've done. In effect, that's what we've done when we've decided that trilogy of cases, is that it's more appropriate. We'll determine whether it's appropriate for a mandatory minimum sentence, but when it comes to whether they've reached that point of maturity and maturation and rehabilitation where they ought to be released, we're leaving that to the Board of Parole to do that. That's exactly what we're doing.
Judge, I don't follow that. I'm sorry, I may have missed the point. I believe Miller says you got to send it back to the court, not send it to the Board of Parole. In fact, I'm sorry to disagree with you, but I don't see that.
But you send it back to the court, and you sentence the person to life in prison with the possibility of parole, and then that's what Miller said, and then you leave it in the jurisdiction of the parole board to decide whether there's not parole. I don't see how the length of this 18-year sentence is. I'm sort of where Justice Apple is, and maybe you could concentrate on that, is by not allowing the court to give probation or a deferred judgment or anything, isn't in fact a mandatory minimum sentence.
Well, maybe I misunderstood, because I thought even in the cases where it's mandatory minimums, then the court would still have an opportunity then to set the years of imprisonment, as opposed to just sending it back for an indeterminate sentence by the Board of Parole. Maybe I'm wrong. I read Miller to say, under the Constitution, a juvenile, because of the difference in the concepts of his culpability, needs the court to look at these factors, just not simply to look at them and send them back to the parole board, but to look at them and set the sentence. Now, maybe I'm wrong in that, and maybe the court, I'm misinterpreting that.
I mean, aren't you, in effect, doesn't your client already get what Lyle contemplated, which is, as your client demonstrates that he has rehabilitated and he's prepared to enter back into society and re-enter and so forth, he has that ability to do so through the parole process?
Well, Judge, I would think in this case, if this scheme is unconstitutional as applied to my client, it would go back to the trial court. He would look at the factors you've set out in Null and in Miller, and those factors are, you can't just look at the nature of the crime. You can't just look at his age. You have to look at his level of maturity, the susceptibility of peer pressure, and all the factors that go into these young gentlemen's life that we keep putting in jail for long periods of time.
But there's no authority under the code for a judge to sentence someone for less than the years that the crime requires. But what this court did is rule that the mandatory minimum component is unconstitutional, as the juvenile struck it out. But we didn't strike out the term of years. I mean, how can this court do what you want to do? Where's our power to set a sentence other than what the legislature has set?
Well, I'm not sure that if it's unconstitutional, that the legislation then doesn't apply. I don't understand if it's unconstitutional, how could then that legislation still apply? Are you telling? I guess what the court's saying, maybe I'm wrong. You're saying it's unconstitutional, but now we have to abide by it.
No,
I don't understand.
I think it runs like this.
Okay, well, maybe I'm misunderstanding.
If under Lyle, as I read Lyle, let's just say some crime has a 7-year mandatory minimum, and a juvenile offender is convicted of that. The juvenile offender is entitled to what we'll call just a Miller-type hearing, and that 7-year mandatory sentence cannot be automatically imposed. They're entitled to a hearing. And as I read Lyle, I suppose if it was a 6-year term or a 5-year term or a 3-year term, you'd be entitled to a 3-year mandatory term. You would be entitled to a Miller-type hearing. The problem with this case is, although it has a mandatory feature to it, there's not a term. It's an indeterminate mandatory. And therefore, I mean, the Court of Appeals is right, very brief opinion, but correctly states it's different than Lyle because there's an indeterminate term. And so isn't the question whether the considerations that gave rise to the Miller trilogy, the peer pressure, the lack of culpability because of neuroscience development, blah, 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 should that have any bearing where you have a mandatory but indeterminate prison term? And that's the question that was open in Lyle. And isn't that the heart of what we're trying to figure out here today?
I guess so, because you're telling me. I guess I gotta agree. I don't agree with that because of the language and the rationale that I'm reading in these cases, and I don't agree that if you hold something's unconstitutional, it's still valid. Because if you hold a statute, let's say in commerce, you say, well, we are no longer going to allow this piece of this product, this widget, to be traded anymore. But there's also underlying what you held unconstitutional, they can still drive it across the state somehow. I would think that once it's unconstitutional, it's unconstitutional. Maybe I'm mistaken. And as to your question, Judge, answering it, I do think on whatever level, if that's the level we're talking about, then I think this case, meets that criteria, and you can see the results that are going to occur to juveniles in this area. Because, the prosecution, once they get the signals, then they can go back and say, well, we won't do these mandatory minimums. What we'll do is we'll do this willful injury times 6.
Well, no, I mean...
Why not?
Well, the remedy for your client, as I understand it, would be an opportunity to present some evidence with respect to his youthfulness and immaturity. The district court might well impose the same sentence,
Sure.
maybe.
Absolutely. That could happen.
Maybe not, we don't know. But if you win in this case, all you get, it seems to me, is a remand back and an opportunity to put on some evidence, but you may well end up with the same sentence, right?
You could, Judge. I agree with that. I definitely agree. I'm not saying the result will be different. I'm saying you need to do it correctly constitutionally. And that's what I think is the most important thing to me, that my client gets that opportunity because, I still think in this case, if it's unconstitutional, he could get probation if they so decide.
Well, Counsel Miller, the U.S. Supreme Court decision was a automatic mandatory life
Right.
Sentence. We're the only court that's extended that all the way down to any automatic mandatory minimum. Has any other court in the country held the way you're asking us to hold now, that you can't send somebody to prison for any minimum length of time without an individualized Miller hearing?
I don't know, Judge, because I don't think anybody's got the Iowa Constitution, and I think this is now an Iowa Constitution issue. And if the courts decide to go, I know it's probably, you've taken a lot of heat. I know that there's a lot of, people out there that have the wrong idea about this, like the judge was just saying. They understand that you're letting these people go. It's not anything like that. You're just giving these kids a chance that, maybe there's something out there that we can still preserve in these kids, no matter how heinous the crime was. And that's a terrible, tough thing for us to do, because that's not the most popular thing to do, certainly, in the world. But I do think the language in null speaks to exactly what I'm talking about. It's the length of the prison term, not the mandatory or the non-mandatory, that triggers the Miller principles and makes it unconstitutional, so that the court system can sentence these kids according to the factors that they so...
That just seems to be such a broad expansion of what I believe that our trilogy of cases says. And I'm not opposed to having any type of expansion, but to me there has to be some constitutional underpinnings to it. In those other cases that you're talking about, we do have long-term, mandatory minimum prison sentences, or even if they're not long-term. I mean, ultimately, when we decided the categorical challenge to it, we just said anything that requires a mandatory minimum of juveniles is cruel and unusual just by its nature. But I don't see how that equates to this, and so I need you to explain, if, with the court's permission, a little bit further, the underpinnings of that.
And Judge, I thought I've been trying to do that. Maybe I haven't been very articulate, but I again point to no. The court didn't say it's just mandatory. It's just the court. I can point to language. It's in my brief. I don't want to read it. That'd be ridiculous. But I think you're all aware of it. But the language in there says they are not. This isn't crime specific. It's not mandatory specific. That's the language, and that's what the rationale. I'm looking at the rationale, not the end result. And if the rationale says these kids are constitutionally less culpable than adults and have to be treated in a different constitutional way, what's the, if so, then the court also has to decide how long a length of the term it is to trigger it. Then to me, what does it have to do with whether it's mandatory or not under the rationale the court has brought forth to go to the mandatory cases? Now we have this forcible felony, and it creates, quite frankly, practically, you're going to see prosecutions go around that, go around the mandatory minimums, like they did in this case. Okay? That's what's happening out there in the real world. And that's why it's so important. Here's my point, Judge, and maybe I'm not very good at doing this, but I just think if this is a constitutional difference, explain to me what mandatory means to a kid coming out of the ghetto that hasn't had a chance in hell to go and make himself a better person, and he's committed a terrible act, and the Constitution says, look, we're going to look at this. You may not get out for the rest of your life. You may be in there for 50 years, but we're under our Constitution. We understand where you are when you're that age, coming perhaps out of this environment. What chance is there to rehabilitate this kid constitutionally? That's where I think the cases are coming from, and that's where I'm coming from. And maybe I'm way off base. So, if I am, you'll tell me, I'm sure.
Thank you, Counsel. You'll
Thank you.
have rebuttal.
Thank you.
Mr. Sloven.
Thank you, Mr. Chief Justice. Counsel, may it please the court? This challenge is new.
Mr. Sloven, I before you get into the merits of the case, I have a problem with jurisdiction here. This was a motion to correct an illegal sentence, and they filed a notice of appeal rather than a cert or mandamus or something. As I understand it, you don't have the statute may or may not allow a direct appeal from a motion to correct an illegal sentence. Can you tell me that? Because we've had many cases where that's been coming up, and I think we need to straighten that out too. So what's the Attorney General's position on that?
So our position on this is that Iowa Code Section 814.6 creates a right of appeal from a final judgment or sentence. In a motion to correct an illegal sentence, when it's denied, there is no new sentence. There's no new final judgment. So there's no right of appeal from that ruling denying the motion to correct an illegal sentence. Now, we don't think that there's no route to appellate review of that ruling. The route would be through a petition for certiorari. But one of the benefits of that is that, well, A, it's in compliance with the statute, and we can't create appellate jurisdiction where the legislature hasn't authorized it. But B, we also get a benefit of clarifying the contours of a motion to correct an illegal sentence, that it really is supposed to be aimed at an illegality on the part of what the district court did.
Well, couldn't we also do it by means of a discretionary review as well?
I think that is also an option. I think that would be...
You're advocating for a certiorari as a path to appeal these types of cases?
I think that discretionary review is appropriate in the exceptional case that presents that important issue to the profession, but the normal route to appellate review of a motion to correct an illegal sentence would be for a petition of certiorari.
And just so I'm clear, in your supplemental brief, I think your position is that we should treat it as a petition for a writ of certiorari, deal with the merits, and then proceed from there. Is that correct?
We're already here, Your Honor. And the Court of Appeals keeps seeing this challenge, so it seems prudent to address it now.
And they've gone the writ of certiorari route, if I remember reading their cases.
That's right, Your Honor.
Let's get into Lyle. I mean, Lyle basically stands for the proposition, and push back, I know you will if I mischaracterize it, but Lyle stands for the proposition that mandatory minimum sentences of juveniles require an opportunity to make the individualized showing. And as I read Lyle, it doesn't specifically give you any mathematics as to the actual lengths, but a short term mandatory minimum, a short term triggers a Miller type hearing. Doesn't mean that you're going to get resentenced, whatever, it means you get a Miller type hearing. You agree with me that far, I take it?
I would agree with that.
Okay,
so then that's accurate.
Right, and then the real issue here, I believe, I mean, if it was a 1 year mandatory minimum, Lyle would kick in. Of course, that's not what we have here. If it was a 10-day mandatory minimum, Lyle would probably kick in. Instead, what we have is a mandatory, but no minimum. And that is the conundrum here, I take it, right?
So I think the better question is, what does Lyle require as the lower bound of what the sentencing court was authorized to do at that resentencing hearing?
Oh, but let me just ask you, if you don't mind. If it was a 10-day mandatory minimum sentence, Miller would kick in under Lyle, would it not?
So I think that that's accurate to a point, but Lyle doesn't require. What Lyle doesn't do is the remedy in Lyle didn't give the sentencing court any authority to impose a sentence that wasn't authorized by statute, didn't allow the sentencing court to suspend a sentence where that wasn't an option.
I could agree with that. I mean, we went through that with Mr. Racette. But the problem is this statute, effectively by having a forcible felony, makes it a 1 hour, 1 day mandatory minimum. And I don't think you could disagree with that.
So I think that it's true that before the parole board can have a hearing, first he has to arrive at the prison.
Well, you have to be there a certain time anyway if you read the rules, so it's really more than 1 day if you read the parole rulings. So the question becomes, to me, does Lyle and those cases require a Miller-type hearing before the judge can send him to jail under the forcible felony statute? And that's the question. I don't think they could sentence him to. I don't think they could sentence him to 4 days and 6 months or come up with some sentence. But I think they could sentence him, and some of the statutes enacted afterwards or later say you give him deferred judgment, give him probation, or do something like that, because that would be something less that's authorized by statute once you get rid of the forcible felony prohibition against those things.
Sure. So just to start, 901-514 based on the majority in Lyle had a brief mention of this. Justice Waterman's dissent in Lyle, I think I wrote down footnote 12, took the position that 901-514, that provision that gives the sentencing court authority to suspend part of the sentence for a juvenile, not retroactive. I think that's the right call. 902.1, the provision for Class A felonies, was specifically made retroactive. The legislature knows how to do that if they choose. Generally, we assume these are prospective
I'm not saying
only.
it should be retroactive. I'm saying, is the person entitled to a hearing, though, before the judge can send them to jail for that 1 day, 1 hour? And it's really almost a year, because you can't get a parole hearing for a year.
And the answer is no. The problem that was identified in Lyle is remedied by as part of the sentence, granting parole eligibility, giving an opportunity to demonstrate meaningful progress towards rehabilitation and demonstrating fitness for release at some point in the future. And
But Justice Wiggins raised a good point. I mean, you would agree that if it turned out Mr. Props had committed the very same acts and gotten the very same plea agreement in 2014, he would be potentially, at least at sentencing, able to argue for probation or deferred judgment, right?
Sure, and that's a decision that the legislature gets to make about whether to give that statute retroactive or prospective only application. I think that's a policy decision. One of the things this comes back to is, and Justice Zager, I think you hit the nail right on the head with this, that unless there's some constitutional underpinning, there's no reason to overturn or invalidate the legislature's decision prescribing certain punishments for certain acts committed by certain offenders. That unless we can say that it's really cruel and unusual punishment under Article 1, Section 17 of the Iowa Constitution, the legislature's judgment about...
But Null didn't nullify the legislative judgment. It just said before you can exercise and enforce the legislative judgment, you have to have a hearing. And I think the best remedy he can get is that there had to be some kind of Miller hearing to determine why he was going to send him to prison rather than give him a deferred judgment or probation. I think that's the best he could ask for in this case. And the hearing may not make a difference, but the youthful offender should have that opportunity to make that showing.
I need to push back on that because I do think that this would invalidate the legislature's judgment by lowering the lower bound of the permissible sentence that could be imposed for this offense on this offender.
Boy, we do that all the time. And the mandatory minimum cases did just that. I mean, the mandatory minimum, of 7 years, the legislature or whatever mandatory minimum it sets, and so in Lyle, for example, we said, well, you're entitled to a Miller type hearing, and maybe you get the mandatory minimum, by the way, but you're entitled to a hearing beforehand. So haven't we crossed that bridge already?
With a very specific justification for it under the Iowa Constitution, yes. Now, when I look at Lyle, and I spent a lot of time rereading Lyle and trying to nail down the analytical framework that would apply out of Lyle to this case, pushing past the consensus, pushing past the text and history and purpose of the Iowa Constitution, I think the real beating heart of that case is, does the punishment further legitimate penological objectives in light of juveniles' diminished culpability? And then the opinion in Lyle goes on to discuss those four rationales: incapacitation, deterrence, retribution, and rehabilitation. And could that punishment, as applied in Lyle, as applied to juveniles, be said to further those legitimate penological objectives? The answer this court found in Lyle was no. I think the answer is very different here, because we're talking about incarceration with immediate parole eligibility. Now, based on what we...
But couldn't the judge in this case, if he felt Lyle did not deserve a day or a month or a year or whatever in jail, say, well, I'm going to give him probation, but put him in a community-based program because this kid is salvageable, and put him in some community-based program. He doesn't have to release him to the world. He doesn't have to have unsupervised probation. He could put him in a community correction place. He could have put him in another place where that rehabilitation could have started immediately rather than sitting in prison waiting for a year for a parole hearing.
I'll do one better than that, I think.
Where there's probably no services.
If the judge at the district court level thought that this was a case where rehabilitation is really the overriding concern, that society's ends and Mr. Props would be best served by treating this with an emphasis on rehabilitation, grant a motion for reverse transfer under 232.8, 8036, and then the criteria set out in 232.45, subsections 6 and 8. It's not as though there's no opportunity for consideration of rehabilitation here.
But that's the same thing, they could have done it in Lyle and those cases, and we decided that any mandatory minimum without a hearing was violated the Iowa Constitution.
Sure, and I think that the important part of that sentence is mandatory minimum. When you're talking about immediate parole eligibility, suddenly the Lyle court's problems with the deterrence rationale, the incapacitation rationale, evaporate. You know, the neuroscience shows everything we know about this curve, this drop-off, that violent crime specifically spikes during certain years in a person's lifetime and then drops off. Well, when you're talking about a sentence with a mandatory minimum, there's not really as much of an incapacitation rationale there, that they may be imprisoned and not able to demonstrate fitness for release long after they're really a danger. But when we're talking about a sentence with immediate parole eligibility, suddenly as soon as they can demonstrate to the parole board that they are no longer a threat to society, that they can be successfully reintegrated, they can obtain release. And I think the neuroscience really supports the idea that if we're going to talk about juveniles being bad at decision-making and more prone to taking risks and more prone to engage in this violent behavior, that has to come alongside a recognition that these offenders can be dangerous. Look at Mr. Props. He shot a man 4 times.
Sure, and the district court would consider that, of course. I mean, the only relief that's conceivably available in this case, really, is just a hearing and an opportunity to make an argument and put on some evidence of, his background or whatever, and peer pressure, et cetera, et cetera, et cetera. That's all. And quite frankly, in this case, I do know it was consecutive sentences. Now, what the district court would do on remand is not 100% certain, but the fact that there were 4 consecutive sentences suggests that the district court regarded this as a serious kind of affair.
And I think that's set out pretty clearly in the sentencing order.
Sure. So, and the district court on remand, if we decided to do a remand, would just there would be a hearing, and the district court could come back and say, well, yes, he was 17, but 4 shots fired, could have been a death, and whatever else is in the PSI report, and so forth and so on, and could even come up with the same sentence, perhaps, but there was an opportunity to present the evidence related to lessened juvenile culpability, and we would then have known that the district court at least considered that and rejected it. It doesn't strike me as terribly burdensome.
That question goes to process, and I don't think that the process is relevant unless there's a possibility of a different outcome. In order to get there, we would have to say that there's a constitutional problem with the legislature's proclamation, which they've now backed away from, but the state of the law as it was, reflecting the legislature's judgment, and now reflecting the judgment not to address those retroactively, that a juvenile offender, 16 or 17, who doesn't get reverse transfer, should go to prison. And I think that's supported by it.
How many offenders would have to be resentenced if we did what opposing counsel of yours is asking us to do?
I don't know.
Well, that's not in the record, is it?
No, Your Honor.
All right, well, let me ask this question. If Miller is tethered to the eligibility of parole, or if Lyle is tethered to the eligibility for parole, what would a Miller hearing do for Props' eligibility for parole?
Unless this court goes further than any of its previous juvenile sentencing cases and finds, and unless we go further than we ever have before, there's no remedy that can be obtained other than what Mr. Props already has, immediate eligibility for parole.
Well, in other words, doesn't Props already have what Miller was seeking to obtain? Or,
yes, Your Honor.
Excuse me, what Lyle was seeking to obtain?
Yes, both, Your Honor.
All right, thank you.
Thank you.
You may present your rebuttal, Mr. Racette.
Thank you.
I ask you your position on the jurisdictional question. How do you get to the characterization that a denial of a motion to correct sentence is actually a new final judgment that you can appeal all over again?
Thanks, Justice. I want to wrap up. Yeah, I think it's not published yet, but I looked at the Dempsey case, and the Dempsey case seemed to cover all the statutes and rules involved in this issue, and they ruled, as the state has said, that they decided that it's either under 814.62E, discretionary review for a legal issue of significance, or you go to the writ certiorari claiming they exceeded their jurisdiction or illegal. However, of course, I have a different opinion, I guess, about that. It seems to me that when you look at 814.6, which if you look at, I believe it's I get the appellate rule wrong here, it's 6.103, I think they looked at initially to say anything on the merits that changes, you get a right to appeal, but it excludes 814.6. So, in other words, you're stuck here with the final judgment as being the sentence. But if you look at Dempsey and what they ruled, they gave real light touch to 2.245A that says you can at any time challenge an illegal sentence. To me, and I've got Arkansas, Indiana, Colorado, New Jersey, they've all said you have a right to appeal from a motion denied for illegal sentencing. And the reason they said that is because if it is in fact an illegal sentence, it's not final. And if you turn the coin or toss that over, what would happen if the motion's granted? Wouldn't, in fact, you'd have a new sentence, and then wouldn't you have a right to appeal from that new sentence on the resentencing?
And as a practical matter, from our side, and I'm actually, get involved in that from time to time because all of us are involved in ruling on motions. We see lots of situations where folks who are currently incarcerated file what they call a motion to correct illegal sentence, and it's not what you did here, but it's something that would probably not be properly characterized that. Wouldn't those folks all have an automatic right of appeal?
I think I know what you're talking about, Justice, but I'm not positive. I think in under those circumstances they would. So I think the court can probably go either way on this. Whatever they decide is correct. I'll give you the language from the New Jersey case. It's an illegal sentence may be corrected at any time because a defendant has no expectation that an illegal sentence is final. And 814.6, how can it be final if it's illegal? That's the quandary for the court to answer. And if you want fewer cases, yes, make it discretionary writ of certiorari because they aren't going to get that at all. If, though, it is truly an illegal sentence, then it's not final, and there should be a right to appeal that, in my opinion, based on the fact that you haven't, 814.6 would then apply, wouldn't apply until it's final, or it would be final at that point. In regard to what was said, I'm not that smart. I probably don't know that much about all these statutes that Counsel cited going into the juvenile and everything else, but I do know that reading these cases over, and I've read Ragland, and I've read Null, and I've read Pearson, and I've looked at, remember Pearson was 35 years, so we aren't far from that, and I've looked at Lyle, and I truly believe, and I know Justice Katie, you asked that question, I truly believe in reading those cases that if we mean what we say, and if this is unconstitutional, and if the trigger here is the length of the sentence, it should be applied to, if it's not categorically unconstitutional in this case, it certainly is as it applies to my client with the number of years he's facing as a juvenile. This man's 17. He got no PSI before he was sentenced. There's been no factors considered of his individuality as applied by Miller. And then I think, I don't know, I didn't understand, Justice, the question that is it tethered to the Iowa Board of Parole. I may misunderstand that. I think if it's a constitutional right that the judiciary has to administer, which I believe the courts are here to sentence people, not the Board of Parole, I think they'll have to come back.
Isn't Props and Lyle in the same boat? right now?
In what way, Judge? Justice, I'm not
Well,
understanding.
if I assume they're both incarcerated with the eligibility for parole.
Correct. Although they've got his at 18 years.
So,
Right.
so Props has what Lyle now has under our opinion.
He may, but Lyle got the advantage of having a court look at his case individually under Miller, which is required, as I understand, by the Constitution. My client hasn't had that. And I
But what's
guess
going to
maybe-
change in his life if he had that hearing?
Well, I think he could be placed on probation. I think he could be
Well, but the statute says it's mandatory, so are you saying that it's cruel and unusual punishment to mandatorily sentence a juvenile to prison?
I don't think it's, maybe I'm missing, again, I don't think it's mandatory. I think it's required for a prison sentence. And that just means, in my understanding, if that's unconstitutional as it applies to a juvenile, then the judge gets to decide what that sentence is. Now, I don't think there's any legislation that would apply at that point. If the forcible felony, mandatory prison, as opposed to a term, would be unconstitutional as to this juvenile. I don't get that. Maybe I just don't understand. I could be not aware of the court's analysis. You'll tell me, I'm sure, so I'll find out. But thank you very much. Thanks. Any other
And
questions? I'm sorry.
Thank you as well,
Okay,
counsel.
thanks.
Case of State versus Props then is now submitted, and we'll next hear the arguments in